stay order. My lord, there is a stay order passed against the AITC. The time is over. Despite of that, it is continuing, my lord. Tuesday, my lord.
Next Friday.
Right.
May I please, Your Lordship? With regard to item minus 16 and 17,
Hmm.
my lord, the record has been called for.
Hmm.
But my lord, the department and asked some more time, my lord. I have taken the consent, my lord.
And then, okay.
20205, that number, demarcation case.
Can we release it?
My friend is yours, sir.
My lord, that free. My lord, as if there is no.
ৰেকৰ্ডটো কিমান টাইম কৰিছে আনি দিম বুলি কৈছে
PK Roy Chaudhary. Let's count
I'm-
for the petition.
I for the respondent, my lord.
Okay, MJ Bolwa.
16, 17.
Land council for the petitioners, petitioner. We got the petitions and Mr. PK Roy Chaudhary. Land council for the private respondents, Mr. N. Das, land engineer, the man advocate for the state respondents are present. So, Mr. Das. Land engineer, the man advocate, some is submitted that. Relevant records of a demarcation proceeding is not obtained. He could not obtain the relevant records of demarcation proceeding, as indicated in the order dated, as mentioned in the order dated 18/11/2025, and has thus paid for, thus sought for some more time to obtain the records. First up, list the case on when.
My lord, at least a week, my lord.
Is the case after a week. Need to fix the right office. And it's the cases are not to be treated as part of and to be listed before the appropriate ones.
Till then, my lord, they should not carry on construction.
How good?
There is no earlier interim order.
There's no.
May I please, Your Lordship? Lordship, I have filed an connecting IA in respect of the item listed at item number 18, Your Lordship. Today is before Your Lordship. It is an intervening application filed by me. So that may be called for while taking up the.
Some other day then.
Pardon, Your
The
Lordship.
other councils are there.
I have given them the copies.
Meeting
Okay, next Tuesday.
along with the main cases,
Huh.
and then interim
Yes,
may be
DK Bhattacharya, you are for petitioner?
petitioners.
A petitioner. Standing council corporation is there.
I have given the copies to all of them.
SK Talukdar,
Miss- And who are the other?
Other,
Also-
Mr. Shantanu Bhattakur is there.
Who is there for him?
A copy is served.
Okay. Mr. A. Vishwas, Land Council has submitted that he has filed an interlocutory application for intervention in the matter as an intervener,
Interview.
in the case. So, and the said the interlocutory application is not listed today. Stop. As agreed to by the Land Council for the parties, list the case along with the interlocutory application for intervention stated to have been filed, on Thursday.
that's 27. Interim may be continued.
The interim order, Australia shall continue.
Highly obliged.
Obliged.
May it please your lordship? Your lordship, with consent of the other side, I beg to mention item 12.
Well,
12,
one
lordship.
minute.
Lordship, kindly adjourn the matter by 2 weeks. As your lordship, the BTC has to obtain updated instruction in this matter.
Well,
12, lordship.
what is it?
Your Lordship, I'm appearing for the petitioner
Oh,
for item 12.
You are for respondent.
Lordship, for Setting Council BTC,
Okay, Mr.
NR Sharma.
You have informed us.
Lordship,
You are for whom?
Petitioner, Lord.
Okay, Miss
R. Chaudhary.
R. Chaudhary, Land Council for the petitioners. is present. Mr.
N R Sharma.
N.R. Sharma, Learned Counsel, representing the respondent BTC authority first. What is your ground for seeking adjournment?
Lordship, we need to obtain updated instruction in this matter.
Okay, has sought for listing of the case in order to obtain up-to-date instruction in the matter, which prayer is not objected to by the Learned Counsel for the petition and the Learned Counsel for the response. It is submitted that Ms. Consent has been taken from the Learned Counsel for the other respondents in the prayer. Okay, the prayer is allowed, leaves the case after 2 weeks.
Obliged, Lordship.
Obliged, Your Lord.
Immediate to fix by the office.
May I please, your lordship?
Yes,
I beg to mention for listing one writ petition, lordship, next week any.
what is the subject matter?
Lordship, land dispute, lordship.
Land dispute. Give it to the court master.
Deeply obliged.
May please lordship, beg to mention for listing lordship, writ petition lordship. Tomorrow lordship,
No, what is this motion?
motion lordship.
What is the subject matter?
Subject matter is that lordship, again challenging a notice, which directed for demolition of foundation of a house lordship. It is on the,
Tomorrow is demolition.
yes lordship.
Lordship, simply for listing of a matter, eviction matter, Lordship. Actually, subject matter involves symmetry, Lordship. So aspect of burials is involved. So
Hmm?
there aspect of burials,
Pending matter or?
pending matter
new
for
matter?
orders, Lordship.
Huh?
For orders, Lordship.
Order.
Some
Give it
urgency-
to the court master.
Next week if.
Give it to the court
Or
master.
limit.
He'll look at that.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 7, lordship. My senior colleague is in bereavement, lordship.
Senior colleague is in
Bereavement, lordship.
bereavement. Who is your senior?
As Banig, lordship.
Oh, he is in bereavement.
Yes.
Yes, who is for the respondent?
LIC report.
Have you informed?
Yes, Lord.
Okay, Miss
F. Begum.
F. Begum, Learned Counsel. On behalf of Mr. S. Bonik, Learned Counsel for the petition, has sought for listing of the case. 2014 matter,
Yes, Lord.
sought for listing of the case on another date on the ground that Mr. Bonik is in bereavement. It is submitted that counsel has been taken from the Learned Counsel for the respondent to make the prayer, respondents to make the prayer. Stop. For, as the matter is of 2014, leaves the case on 4th of December.
Right.
Lordship, I beg to mention a writ petition for listing your lordship next Friday in admission stage.
Admission stage.
Yes, Lordship.
Okay,
Next
give it
Friday.
to the court master.
Obliged, Lord.
Your Lordship, I beg to mention for listing one writ petition on Monday.
Monday? What is the subject matter and motion?
Subject matter of the writ petition, petitioners who may be affected from their homestead patta land due to the construction of
Motion matter? Motion?
motion.
Okay.
Supplementary list for motion, item 13.
Yes, Mr. Taludra.
Lordship, we have communicated but not received any instruction. I asked him to talk to him over phone, but he did not get that. And registry was also directed to.
Registry has not received any status report.
Registry also have not received anything.
So you communicate over phone? We'll take
Over
up
phone,
after
I'll
some
try
time.
again,
We'll take up. We'll take up after some. At
My-
2, at 2.
He was trying, my lord, or.
Make an effort.
Lordship.
Thereafter we'll adjourn.
Item 14. Lordship, in similar matter, Lordship, coordinated with pass order, Lordship, may please. Okay.
Lordship, may kindly pass over the matter for timing, Lordship.
Let me see the order.
Yes, sir.
Same issue, Lordship.
Okay, when Miss Harlia will be available?
Lordship,
It's a
short
good
time.
order. Balanced order.
Lordship.
Within short time, she'll be available.
Hmm.
And this is basically our prayer, Lordship. Disputed, because their Kochini Lordship, they are not entitled to pay interest.
I will not have passed the order also. Now, the Korean bench has passed the order, so it is to be respected.
Lordship.
So we'll respect definitely. Take your call, show it to Miss Harlia.
Readiness for admission, item number 1. May please. Furnace, my lord, on the other day, that start not on.
Many judgments were also cited.
Yes, ma'am.
এইবোৰ বেলেগে কৰি দিব বাৰু আচল ফাইলটো ক'বাতে গ'ল আচল ফাইলটো ক'বাতে নাইকিয়া হৈছে হেৰিৰ কোড চাইটেশ্যনৰ কোডত Main case is lost among citations.
Yes, madam.
We should log ID. Yes, what is the main case? Thereafter, go to citation.
My lord.
Like what? This is stop this type of something. Let us have the main petition, then we'll go to the list of dates.
My lord.
So you are a contractor under Water
Yes, ma'am.
Resources Department.
Yes, ma'am. In terms of NIT dated 13/2/2014, issued by the Executive Engineer, North Lakhimpur Water Resource Division, my lord, I was allowed certain works of
Thirteen to Executive Engineer.
yes, ma'am. Certain works for flood management of River Ranganodi along with river training works on boat bank embankment in Lakhimpur district. That NIT is not a part of that. I'm furnishing. I have managed the schedule and work order, my lord. NIT.
Okay, come to page 25.
My lord. Yes, my lord. This is the schedule, my lord.
This is part of the NIT or?
My lord.
Or this is something LOI. Your name is there?
Yes, my lord.
Okay, read 24.
My lord.
Read 24.
Reference this office preliminary work order number 26. As you have signed formal tender after deposition of SD money, your tender for the above noted work has been finally selected for acceptance at the rate as noted in Annex 1. Please start the work in consultation with the Assistant Executive Engineer, North Lakhimpur Water Resources Subdivision, North Lakhimpur, and then show proportionate progress against the stipulated time for completion of work in above mentioned work within 7 days time from the date of issue of the formal work order without fail. Please note that the time for completion of the above mentioned work will be 45 days only from the date of issue from the formal work order, beyond which this order will be cancelled from you and action as per the condition of the agreement will be taken. Item work as per schedule and of item and rates annex at annex 1. Rate value of work 2,92,55,425. Next, this is the schedule, my lord. Schedule at item 1, my lord. Artwork in embankment by truck carriers in locally available ordinary soil excluding rocky soil free from roots and vegetation and filling in uniform layers not exceeding 22 cm thick, including cutting and cleaning light jungles and trees up to 50 cm. Yeah. Plowing or roughening the benches, seats, removing all debris, breaking clothes up to 22.5 cm cube, dressing as per design section, including payment of compensation for borrowing art from private land or forest royalty, if any, etc. Complete as directed, 10% deduction will be made from the section measured quantities of the completed and compacted section artwork on account of shrinkage. So this is the quantity mentioned. Item number 2 also there, my lord, turfing with grass wood.
No, do
So
it.
largest possible rectangle of the minimum this closely including dressing, art, pegging with jati bamboo split, watering till the grass grows for a
Grass has to be grown.
my lord.
Okay.
So this is thereafter that formal contract was executed by stipulating the condition of contract, my lord. This starts from page 26 and up to 40. It is the type copy up to page 60.
Up to page
55, my lord.
55. Anything relevant there?
My lord, only I want to show from that condition of contract that there is no specific mention of from where the soil to be collected. And there is no mention in the contract of that regarding the notification of finance department of 2000 million.
Including payment of compensation for borrowing art from private land or forest royalty.
My lord.
It is there already.
Yes, it is there.
Uh,
No, that is two part. Compensation for borrowing art from private land and
or
forest royalty, if any, my lord.
yes. Conditions of the contract, anything? On forest royalty or private
No, my lord.
land?
No, my lord.
Nothing.
Nothing. So I have specifically stated in my writ petition that there is no clause regarding from which place that material to be collected. I collected from the open market. From Pattalan by executing some agreement with the owner, and I have paid the compensation to them.
Take us to the affidavit.
Paragraph 6 of my writ petition. Mary.
Yes.
Upon the allotment, the petitioner started execution of the said contract work by procuring material from open markets, since the department did not specify source from where the material to be collected. The work was executed by the petitioner by collecting the art from private patta land for which the petitioner has paid the compensation to the landholder at the specified rate. It is respectfully stated that the petitioner paid the landowner at the agreed value of land, and in turn the landowner, by swearing affidavit before the notary public, declares that the patta land have been utilized for construction of embankment against the scheme, namely flood control of river Ranganadi along with the river training works on both bank embankment in Lakhimpur district by work order number so and so, and they have been paid the legal value of the such land by the petitioner. Lordship will find page 59 of my writ petition, my lord, annexure 4. That is the report by the executive engineer, North Lakhimpur Water Resource Division, my lord.
80,
59,
59.
my lord. This is the progress report, my lord.
Huh.
My lord, this is in respect of the petitioner Pranjal Gautam Pal. And at column number 1, 2, 3, 4, 5, your lordship will find the up-to-date progress 100%, my lord. If completed, the date of completion 10/11/2019, remarks on contractual performance satisfactory. So work was executed as per the norms, my lord.
Then what happened?
Then your lordship will find it annexure 5 at page 60. This is the first bill passed by the authority, my lord. 61 is the relevant page, my lord. First part payment. Passed for 1,05,15,175. Income tax deducted so and so, VAT so and so. And then your lordship will find a forest relative rupees 15,07,775 and income tax on forest relative 37,694.
This was deducted.
My lord, already deducted.
What is the date? When?
Date it was, lordship will
2018.
find it page 62, my lord. The process
2018.
they have initiated, process 29/2018.
Then
Then the final bill, my lord, they have processed, my lord, of rupees 1,06,65,250, my lord.
where is that?
No, that I have made a statement, my lord. Then at that time, we have approached this court, praying for no,
You are objecting to deduction of this forest royalty.
my lord, and income tax on the parcel.
Okay, and where is the statement? Final bill?
Final bill, your lordship will find it page 8, page 10 and paragraph 8, my lord. Mary. That is stated that the first bill of the petitioner was released in the year 2015 amounting to 80,75,000. Thereafter, the part payment, the second bill by the member number so and so, that is so and so, the bill for rupees 1,05,15,175 was processed and passed by deducting the relevant taxes, including income tax, SGST, the GST, LCS, SD. It is stated that in the said part payment made by the department, an amount of rupees 15,07,775 was also deducted for forest royalty, and amount of 37,695 was also deducted as an income tax on forest royalty. It is stated that after deduction of the said aforesaid amount of rupees, after deduction of the aforesaid amount, a sum of rupees 79,72,949 has been received by the petitioner as a part payment. After such payment, a sum of rupees 1,06,65,250 is now due by the department on account of the execution of the said contract work. Next paragraph, paragraph 9, my lord. that it is stated that the respondent authority is now processing the payment of bill of rupees so and so by deducting 10% of the said amount as a first royalty on account of execution of the artwork. I have stated, well. Lordship may take up the note I have. Furnished, well.
My lord, just today I am a bit handicapped because this matter is originally with the water resource. Though Mr. P.N. Goswami was given the brief, today he is not here, and I too find it very difficult to go through it once. Otherwise, only I can make an attempt. But it told me
No,
very
if you're
with full
not
force.
here, then it will be difficult.
Yes, my lord. I can make a feeble attempt, but it should be very convincing.
Only, my lord, I have furnished the note on which I have
Otherwise, my lord,
the
there
grounds
was a
taken, I have taken the grounds, my lord. Only I will reply to that. If the other side.
in one case, my lord, which I had appeared, there was a writ appeal, my lord. The same issues were perhaps lordship may kindly.
Yes.
NC does.
Yes.
NC
That
does.
is in the
NC
record.
does. It went for writ appeal, my lord. We are asking for the source. That the the mineral which we have brought is from a valid source only. This was agitated, my lords.
And see us. Yes, yes. Yes.
I think if I remember, there is something more
Yes, madam.
here. Somewhere we have seen some, and we asked, I think RM Das, if I remember correctly. It has been, though it is not parted or kept for this man, but somehow it is coming back to me.
That the petitioner applied for the that
Ah.
will be in the IA, my lord, that is disposed of.
Mhm.
Is applied for. Huh?
In the IA,
In the IA, my lord.
some more documents.
My lord. Is applied for, but it was not granted.
Permit.
Permit, my lord.
He asked for permit.
My lord. Yeah. In terms of rules 27, my lord,
Hmm.
he applied for the permit in the specific form, my lord.
And why we deferred it? Because the judgment cited by both the sides, if I remember correctly, none of the judgment have referred to
Rule 20. Rule 27.
27
Yes.
of the Assam
Minor
minor minerals. Right. When the statutory provision dealing with the issue is there, and the judgment cited are not referring to that
My lords.
provision, then we have to independently
My lords.
think it, what is the relevance of that statutory
Correct.
provision. Right, that is why the issue was deferred earlier.
Normally, the process is when a contract is floated by a government agency, they have to come to us. There is a rule 5, exception is carved out. We can give permit that PWD of irrigation will write to us, then we'll issue permit to the contractor. Only because of deviation from that rule has given rise to this thing. If they have strictly followed that rule, this
Contractor applied to the range officer.
my lords.
Yes, ma'am.
Range officer with a favorable report forwarded to the DFO, if I remember.
Yes, ma'am.
Yes.
And DFO set on it.
Normally, actually, my lords,
And
the
there is a specific time. to
And
execute the-
statute
now
says
the
that the
things
department should come.
Things coming back. You said rule 5.
Rule 5, my lords. Rule 5 it over. Minor minerals concession laws. Musa আছে। It exception it was.
Yes, he made the application to the range office.
My lord.
The range officer forwarded it to DFO. So if we read rule 5, DFO did not forward it.
My lord.
And on the other hand, time is of essence.
Yes.
So he has shown some agreement with the landowner.
My lord.
He carried it, done it for the Water Resources Department.
Otherwise,
So what will be the implication of this?
otherwise,
Because the contractor engaged, next 5(2), engaged for works projects of the government department. He is doing it for government department. Shall be granted mining permit for the required quantity as specified in a detailed project report for execution of the works. On making an application under sub-rule 1 above. So he shall be granted.
shall, yes, mandatory. my lord.
So if some inaction is attributable to the department, what will be the consequence? Because 27. So if any of the judgments have dealt with rule 27, no issue, then I'll go by it. Any of the judgment you cite that it has referred to rule 27.
Even rule 5 also has not been touched.
Huh.
Nowhere. Only
And this is,
simplicity argument is
at
that
least
it is a
this
minor.
is applicable from 2013.
Right.
Other previous judgments, you keep it
Different
aside.
rules, my lord, 95 also.
Prior to 2013, you keep it aside. When the statutory prescription is there, it has to go follow it,
My lord, yes.
right? So that is why I asked, because so many judgments have been cited, few of them are silent on anything. Assam minor mineral concession rules.
And most pertinent, my lord,
Yes.
for schedule, my lord, it doesn't specify any rate on the art, my lord, in 2013, my lord. That was a specific plea, my lord. It
I know,
was
it's one of them.
subsequently
Minor
brought in by
mineral-
amendment in 2021. my
minor
lord.
mineral concession
No,
rule.
no, তাৰ answerটো বেলেগত আছে। ই কিতাপখন চোন, some-
Oh, এইখন আছে, no, এইখন। Oh. There you see 27, rule 27.
My lord.
Permit for extraction of clay art.
My-
Save in cases under sub-rule of ordinary, sub-rule 2, I think,
Sub-rule 2 of
Of
Rule 26.
6.
The
Competent authority may grant
permit
permit.
for lifting the ordinary art from an area not really granted to any mineral concession to
Or
the landowner or the person having consent to lend,
here he is showing consent.
my lord.
Here he is showing consent. Next,
The permit for extraction of ordinary art shall be granted only up to a maximum depth of 9 feet measured from the natural ground level of the said area.
Hmm.
The permit of extraction of ordinary art clay in respect of any land which is the ownership of
This is not-
Not applicable.
Hmm.
4 is pertinent, my lord.
Hmm.
The royalty shall be charged on lump sum basis on a basis of quantity per volume on the art for which the permit is applied or granted as per the rate prescribed in the first schedule.
Hmm.
The payment of royalty in those cases shall be made in advance for complete of for the complete of financial year or part thereof.
Hmm.
Well, this is the ground, my lord. And I have applied in the specific form.
An application process shall be submitted in PIM.
PM3.
Okay, PIM3, you
The
have done.
application for grant of permit shall be permitted in a model form of PM3. The
You have
application-
done.
Yes, I have done, my lord.
Okay.
That consequent order was not passed by the DFO.
And now,
DFO should have forwarded it to the body which grants clearance, environment clearance. And
Where is the
building permit-
competent authority?
My lords,
What is competent authority?
Hmm?
I think competent authority may grant section 5, rule 5.
competent authority.
And made by an officer.
No, it will dilute regulation.
Somewhere while dealing with other cases, found that DFO is competent authority.
My lord, there's a rule, delegation of rule.
A delegation.
Yes,
By delegated power.
Yes,
Somewhere
yes.
I have say,
Ma'am.
found it.
Yes, my lord, this question comes, my lord, when tenders are floated or challenged.
Rule 2. E. Some delegated power is there.
Yes, my lords. Up to a capacity of certain earmark financial power.
Hmm. Then what is permit?
Permit, my lord.
Meaning permit.
Permit is defined.
Means a mineral concession other than a lease. Granted for a specified quantity of minor mineral to be extracted, collected.
Not
in a
exceeding 2
specified
years.
period, Not exceeding 2 years in specified classes on payment of advance royalty.
This comes, my lord, when we float tenders for
No.
settlement.
This is also permit is also have to be read in rule 27. So has any of the decisions cited by the parties have dealt with this issue?
No,
27 is not.
no. 27, even rule 5, not us. Argument simpliciter is that art is a minor mineral. Somdat builders had said so, pay royalty.
So ready?
Up to that extent, my lord. Otherwise, I'll be trespassing in the area of additional AG, my lords.
Hmm.
Since it may have some implications on the state exchequer also.
It has been amended when?
My lord.
Royalty from nil to.
Yes, it was in 2021, my lord. I have furnished the copy, my lord. That at that time, the royalty was 0.
No, এটা বেলেগ আছে। 18 ত was
আমার তো 30
2000?
18 ত regulate amend কৰিছে।
A forest regulation actually.
Well, if rule 5 is followed, then there's a notification which is a part of Assam Forest regulations. There is a chart which prescribes certain amounts of royalty. Schedule rates are there.
That is, I think, this is from the prospective effect. In rule amendment in 21. It says,
বেলেগ concept.
21.
yes,
21.
Ordinary art. You have fixed the rate.
my lord.
So this is in between. Now you are
Well, there's a notification
caught
of
with
2018.
rules, not with judgments. Old rules.
এখন বেলেগ এখন আছে 18 এখন আছে 18 এখন
18 আছিল।
8 আছে।
But in 2013, 18. By specifically, my lord, in 2013, there is no rate for ordinary art. Subsequent, my lord, amendment, it will not come into play.
Regulation. 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 Assam Forest regulation. Okay. Manual committee. Come to KTS also.
Come to 2013. 12, 13, 12, 10, 13. 14, sorry, 14.
If my lord takes up the Assam Forest regulation book, at page 53, there's a notification of 2009. Schedule of rates of royalty leviable on all classes of forest produce in Assam.
Then we'll have to go by the definition of forest produce at.
One minute, no,
I'm just trying.
Argue both from both
Yes,
sides.
yes.
I cannot follow two.
Yes. Page 53 starts.
Yes, 53.
53. This book, if Lordship holds the same book. 53 minutes. Then the heading, my lord, will see the schedule of roads, royalty leviable.
Schedule.
Yes, my lord will directly go to page 62.
Page
62. It prescribes a rate. Clay and earth, rupees 15 per cubic meter.
plain earth,
Clay and earth.
15. This will, on the other hand, forest regulation and Assam Land and Revenue. Forest regulation cannot deal with Assam Land and
Yes,
Revenue
yes.
Regulation. And Assam Land and Revenue Regulation cannot deal with
Forest.
forest regulation. And periodic patta can be exclusively dealt with by the provisions of Assam Land and Revenue
Right.
Regulation.
Regulation 4.
Yes.
Right?
Yes.
Now you are encroaching into an area which is dealt by Assam Land and Revenue Regulation.
Otherwise, my lord, at page 52 or 53.
Because
It
charging
is-
section for tax, levy, duty, royalty has to be by specific, very specific.
My lords.
The source of power has to be there.
Right.
Now, if we go by this, I think that is a dilemma because you have given me 10, 12 judgments. I have not got time to read it. Then suddenly it caught my mind, these are the provisions. Okay. This is to be dealt.
My lords.
We keep it part of it.
Yes.
2nd December. Right.
Always.
Anything other than Assam minor mineral concession rules, it has been framed under Mines and Minerals Development Act, then Assam Forest Regulation. And if you refer to it, then Assam Land and Revenue Regulation will come.
My lord.
Yes, permits should be obtained,
Yes.
even if you extract from periodic patta.
Yes. That's
At least, but transit, whatever,
my lord.
it is there. If not, for regions attributable to
Us,
First of all.
for time being, my lord, us.
for a time being, then what is the consequence? Consequence is forest royalty,
No,
or he is to be booked
yes,
under penal provision.
there is a specific provision for.
My lords.
Have you got it?
I got,
If he has done it wrongly, he made the effort, which is not something grant of obtaining a permit, is not within his control.
my lord.
It is in the control of the forest authorities. They do not do it. On the other hand, he is facing termination of contract,
My lords.
2 crore something. He had done it. Your minor mineral concession rules say my royalty is 0. Let us assume for a moment. Concession rules. Then what will be the other consequence? None of the judgments have dealt with minor mineral concession rules to 27, rule 5. Right. That is the dilemma. That is why I asked you that you produce us some judgment which dealt with rule 27. Because here he had done what he had done.
My lord.
Had he simply annexed his application, we could not have taken cognizance of it. But your range officer examined it, recommended it, and forwarded it to the DFO. So meaning thereby, it's stuck in the office of the DFO.
My lords.
So
Correct.
even if it is not, even if it is done, royalty is zero. So there is no question of advance royalty. If something is zero, no question of advance royalty.
My lords, 0 multiplied by 0.
So if he had done, had there been a royalty, rate of royalty, you could have
Imposed, my lord.
imposed him and with penalty.
Right.
If there is penalty provision. That 10 is the rate of royalty plus penalty of the same rate, 20%. You recover. You cannot recover now. Because he had done it prior to your amendment. 9% royalty you have brought in 2021. So he had completed the work prior to your amendment. So you cannot give that into retrospective effect.
Right.
So this is any judgment you show us, we'll agree to it. Right. Second December.
Milord,
Third is there.
on the.
Anything
other
more?
date-
Yes.
Any other date, take two, Milord. I'll be out of station.
Because other days I'll be out of state.
Oh, okay, Milord. Second. Second.
Or we can do it fourth.
Fourth.
Fourth. Okay. P. Hazarika. Petition. D. Gogoi. Standing Council.
My lord, for the forest.
Okay.
First party night.
Forest is not a party.
Oh.
On behalf of changes.
On behalf of Mr.
On
PN.
behalf of Mr. R.M. Das.
My lord. No, my lord, let it be PN Goswami.
On behalf of Mr. P. N. Goswami. Okay, learned, additional
Yes.
for a state response. Hearing is not concluded. Is the case. On 4/12/2025. As brought forward by the Learned Council Board of Parties. As a partner David.
Obliged, my lord.
The interim order that.
Interim order passed.
My lord. Obliged.
Econo video.
Item 2.
Mr. Nayak. Well, you're supposed to
Yes, I have.
file.
Yes, sir. Yes, sir.
You filed it yesterday, man.
No, not record.
Manoj. I have an extra copy, Your Lordship.
Oh, that way we cannot.
They committed to file it by 11/11.
Yesterday, what I agreed. We had to pass the order that raise it or dispose of. Raise it to trace out the affidavit and tag it with the record. But if it is not there, I'll be at fault. Okay. What is the matter?
My Lord, our lands were, my Lord, these are tea gardens, my Lord. They were
Acquired.
not exactly acquired, my Lord. They did it under a scheme which is known as the acquisition through direct purchase.
Oh, yes.
Now they agreed on a particular quantum, my Lord. Agreements were executed. We handed over the land, my Lord. Then they turned back and said, now we will do it as per. They made half payments, my Lord. Thereafter, they said we'll do it now as per the new T zonal value, and thereby had substantially reduced the consideration. That is the difficulty, my Lord. We've already surrendered the land. The roads are built, my Lord.
Okay.
It's not going to be funny.
What was the number, Asli? It was more to program yoga. All dated, it was November. Is after is peace. After should you buy, no? 27? 27? Next Thursday?
Can it be 26th or 25th?
20?
5th or 6th?
25th. Few matters are fixed on 25th.
I don't know.
Not possible, 26th.
27th,
27th.
26th. 27th, my lord, I have another matter fixed.
28 then, 28.
In the next month, also.
Huh?
First week or second week of next month.
Okay.
Second.
9th of December.
Second.
9th of December. Okay, BD Decca. For the petitioners. Mr. B. Goswami and Mr. P. Nayak. How do you record? Two advocate generals, additional advocate generals?
Government notified.
Okay. Mr. B. Goswami and additional advocate general Assam for the state respondents. Mr. P. Nayak. Standing council PWD. Standing council PWD are present. First of Mr. It is submitted by Mr. Nayak that the affidavit of the respondent PWD authorities has been filed yesterday with a copy to the Learned Council for the petitioner. So, as the said affidavit of the respondent PWD authorities is not on record, office to trace out the same and list the case on 9/12/2025 as agreed to by the Learned Council for the parties, as agreed to and sought for by the Learned Council.
Endeavor to dispose.
That
was there.
will be made to give consideration on the return. Right.
Items 3 and 4.
think they have filed an affidavit by the PF. There is an order, your lordship will kindly see, last order passed by this court.
Four 11. Last order was on 4/11.
4/11.
Huh.
Yes, 2 weeks time, I think, 2 weeks.
They were supposed to file how the amount is utilized.
Yes, correct.
How much amount?
File.
They have filed, it is not on record. So I think that I have to also, we are for the bank, my lord, we are for Punjab National Bank. There were 2 gardens belonging to Assam Tea Corporation Limited. And these were leased out. And accordingly, the lessee has approached us because the Assam Tea Corporation has said that you have to take a loan because there's a garden, huge garden. And they approached us and we funded them. But there was after funding it, there was a due, which is due to the PF, and it was not paid by the lessee. Ultimately decided to take over this garden. And thereafter, it was put on sale by way of an auction. Now, this amount, now it has been kept by deducting the amount which the PF dues, they deducted. Rest amount is lying with ATCL. So, our case before this court was that this amount is due to us. And the margin, the amount, term loan has been paid directly.
So who is
to
the
ATCL.
owner of the tea gardens?
Assam Tea Corporation Limited. They are the owner of the garden.
Okay.
They are the owner of the garden.
And 2 tea gardens.
2 tea gardens. These are packets.
And
There were a number of gardens was put to lease, but we are concerned.
put to lease to whom?
A lease of anyone can buy an RFP. It was invited RFP.
Okay, it is RFP.
RFP.
So it was granted to?
One Mr. Private respondent, to one of the private who participated in the RFP.
Okay. So he was selected.
He was selected.
He was granted.
Yes.
What
correct.
kind of right?
I'm sorry, my lord.
What kind of right he is getting
No,
by
no.
that?
I am not for, I am for the bank.
Right, no,
Yes.
I have to show the.
Yes.
We cannot go into that.
Yes.
The sequence of events.
Yes. The right is only for running this garden for a period of 30 years.
Okay.
For 30 years. But he could not run the garden for 30 years. After 1 year, it
So what is the relationship legally?
yes.
Legally between the RFP selected
bank,
person
yes.
and Assam
Assam Tea Corporation. Limited.
Corporation.
Now, my lord, there is one.
They remain the owner.
Yes, yes. That's
It was some rights
correct. Right.
by RFP that man got.
Man, I have
That man got.
correct.
Right.
Yes.
But ownership is retained by
Assam
Tea Corporation.
They are the owner.
Now they step in this provident fund.
Yes, correct.
They exercise their statutory power. That you as a so-and-so PF, I think,
Yes, correct.
PF so-and-so, these are statutory dues, you defaulted. So the aim is towards Assam Tea Corporation.
No, the default.
Whoever
by the
made,
lessee, who is running the garden.
ultimately it is the owner.
Yes, yes. He becomes.
Ultimately the default will be attributable to the owner.
Yeah.
Then they started exercising their power.
Yes.
Then auction.
Yes.
I think nobody could stop it.
Yes.
So it materialized.
Yes.
Somebody else already purchased it.
Yes.
So tea garden is gone
Correct.
out
Right.
of Assam Tea Corporation also.
Yes.
Now, what the prices are fixed by a provident fund organization.
Yes.
They realize their money.
They realize their money.
They realize their money.
Money.
Now, some balance.
Some balance went to
Some balance.
Yes.
So to whom it is to be given?
Yes, correct. That's the very correct. Right.
I think that is the issue.
That's the issue. Man. That's the issue.
Now, you gave loan to that
Yes,
RFP.
Yes. Correct. Right.
So what
My
you
yes.
took as a security?
Yes. My particular, if I have taken a particular leasehold right, I have taken a security. Leasehold right. Now there as per the 2016, there is under the Surface Act. Now the leasehold right, there are which was earlier it was not there. Hire purchase and leasehold right now have been given to all the financial institutions. So we are now saying that some of type by way of a leasehold right is been accrued. So now our whole case is that whatever the money is now lying with the Assam Tea Corporation Limited, that is being a public money, and we pay directly to you the term loan, which is lying with them. This money you should return back to us.
This money is meant for as public money, both for Assam Tea Corporation as well as for the bank. That is also a state government undertaking.
Yeah, correct, my lord.
Right.
But once they have sold it, it's gone out
They
of
got
their
it as
hands.
a owner.
But my lord, the only problem.
Remaining is otherwise.
Yes.
If you were not there in the picture, this bank and RFP, I am saying just
Yes.
for RFP, if you were not in the picture, they could have got the
They could have got.
remaining money.
Yes.
So you try to sit over that money.
Yes, right.
What is the right you have?
Yes, that's what we are saying. The right is been accrued by virtue
What
of
kind of agreement?
Right. Agreement. Well, I'll tell you by honesty, my lord, there is one agreement which is not a bank is not a part of it. Let us put in because that's a fact. The agreement is only between the lessee and the lessor, which is the Assam Tea Corporation Limited. We don't have any part of an agreement. There is an agreement. Now your lordship may ask, what is your lordship? Rightly ask, what is your right? Because ATCL is there. You did not have any agreement to that effect.
To what extent that RFP man
Yes.
can give you security over his leasehold right?
Now this is known to the ATCL because Assam Tea Corporation Limited.
Let us have the.
Yes.
But this money affidavit is not there.
My lord. it has
Money
to be-
affidavit is not there.
Yes, only my concern.
Remaining money.
Yes. My lord, they have filed an affidavit before the court. I think that we all have to give a reply to it. Because what they have done it, now, my lord, the Assam Tea Corporation Limited on the last.
You
to
are
last,
keeping it?
they have retained. There is no problem in it. Assam Tea Corporation Limited now sought for before this court by saying that the bonus entitled, because there are workers earlier and they have to pay a bonus. Now the bonus extend, your lordship, no, if it is not a profit making garden, so only the minimum bonus the workers are entitled, 8.33. But the maximum bonus they want to give it. So we raise, they have already disbursed by virtue of this. So we want to give a reply. Ultimately, when they disburse this way, nothing will remain. End of the day, they will say all has been taken away. So I will come with a reply with some IA, my lord. So your lordship will kindly allow this to us to file a.
Okay, let us bring it on record.
Yes.
That affidavit, when did you file?
Yesterday, madam.
Everybody, on the last date, we do not have the affidavit. Mr. D. Das, Land Senior Counsel, said by Mr. A. Ganguly. For the petitioners.
For the petition.
For the petitioners. Mr.
J Bora for 6 and 4.
J. Bora, Land Council, appearing for
6
the
and 4.
respondent ATEPFO authorities. Same. Industries Commerce. Who is he? Okay. Mr. H. M. Bhuyan. B. Gogoi. Land Council for the respondent ATC. Poster. Mr. Bora has submitted that an affidavit on behalf of the ATEPFO authorities has been filed yesterday in deference to the order dated 4/11/2025. However, but the same is not part of the record. Mr. Das, Land Senior Counsel, appearing for the petition, has submitted that the petitioner has been served with a copy of the said affidavit, and the petitioner intends to file an appropriate reply to it. So how much time you need?
Malo, we'll take 5 days, 1 week only.
Okay. As okay. Raise the case on next Thursday.
But if it is not inconvenient, your lordship, can it be on 9th, my lord? If it is not inconvenient. Find my learned pen. 9th is Tuesday, my lord.
Let it be on 11th then.
11.
I have already put one.
11.
No. As sought for and agreed to by the Land Council for the parties, release the case on 11/12.
Obliged.
Deeply open.
Item number 5.
May I please, lordship?
Yes. Some deduction.
Lordship, in this case, I am appearing for respondent number 2 and 3. Lordship, I have received oral instruction. The case of the petition is that bank is deducting TDS from his pension account. Lordship, my officer informed me that he can download form 26 AS from, because this is a form is personalized. Then we can verify or let's say on other side, the pension is a taxable. If he has to file return, claiming a exemption. Yes, exemption is available to him, but he has to produce all these documents before this. Because no income tax has been placed, return has been placed before this honorable court.
The pensioner has to submit ITR or not?
Now they have stopped, my lord, deducting. Now they have stopped, my lord. After filing this case, they have
But
stopped.
whatever deduction has been made,
Yeah, that is, my lord, that records is not available with me, my lord. I have filed RTI application with the bank, my lord. No statement.
no, he is an income tax assessee.
Yes,
No, he is, my lord, only 31.
Really, during service period, he was an income tax assessee perhaps.
but see, he has a separate PAN card number also.
There, my lord. But only
So whether
31,000.
he submitted the ITR or not during the relevant period. If your case is that you are below
Yeah, tax,
Taxable.
taxable limit.
Yes.
But for that also you have to submit ITR,
not, sir.
is it not?
Not, sir. Yes.
Being a government employee or a pensioner, I think it is my common sense, I don't know.
Not say if it is because
Bank,
it's
my lord, last of the bank says, my lord, PAN card was not updated, my lord. That is why deduction was made. But now PAN card has been updated, my lord. So the amount already deducted, my lord.
So what Mrs. Kyle is saying, that 26 AAS
AAS,
would show the deductions
not say,
if you have a PAN card. That is your case.
not say. Not say,
And thereafter they can verify. So if you have a PAN number, you can download 26 AAS for a relevant period,
I will take instruction.
right? You can download.
not say.
Then everything will be reflected.
Let's see, another thing, whether he has filed any return for the particular years. Because let's see, since the pension is.
Which provision says it is mandatory?
Let's see, I'm. 90.
When you are coming out with simplified income tax act.
Let's see, from 1st of April 2026.
Okay, good.
Act has only passed, that has been published also.
I tried many times, but I could not understand anything.
So many amendments are there, it is very.
I could not understand that.
Correlate, it is sometimes difficult.
I am always at the mercy of CA. Whatever he has done. Which provisions?
Let's see, section 194.
The name? 194. One 194 is dividend.
Let's see, there are many
Yes, sir.
subsections are there.
HR Amir Lani Council for a petitioner, Mr. S.C. Kyle, Standing Council Income Tax Department for the respondent was 2 and 3. What are the relevant period, Mr. Ahmed?
2020, as per my instruction, my lord.
During period.
Exactly period also not confirmed by the petitioner. He is 85 years old, my lord. He filed RTI application before the bank, my lord. Bank did not supply anything, my lord.
But in his application, he said that 1st of January 2022 to 1st of August
The
2022.
petitioner has claimed it. Who deducted it? Bank or fraud?
Bank fraud.
The bank, has stated that the petitioner maintains a savings bank account number at Lanka branch of Punjab National Bank. So as the petitioner is a government pensioner, his monthly pension is credited in the said account. Post of the petitioner noticed that during the period from 1/1/2020 to 1/8/2024, the 24?
24. Yes.
You said,
Yes.
it is your case,
Yes, my lord. Up to 24.
comma, tax amount, his pension, monthly pension amounts were credited after deduction of TDS by the bank. Full stop. The petitioner's contention is that as a pensioner, the amount he received yearly is below taxable limit and he is not required to pay any income tax. Full stop. If either states that he has a permanent account number, full stop. Whereas Mr. Carl, Standing Council Income Tax Department has submitted that if the petition basis 26 AAS form,
Lordship.
then the income tax department authorities can verify the amount of tax, amount of TDS, if any. Full stop. We have further submitted that as the petitioner is holding pen, the petitioner can download
Yes, Lord.
the 26 AAS forms. Full stop. Mr. Amit, Learning Council for the petition, has sought a week's time to complete his instruction in the above aspect. Full stop. Raise the case on video.
10-12. Obligation, much so.
Welcome back. Just
Entire 101 bighas belong to Khotole. This is what the verdict of the border. But they never tried to implement or records of the right to be corrected. Because original, the landlords, legal heirs of landlord, their names were there in the records of right. Because these are Brahmotar's property, which was given at that relevant time 100, 200 years by Aum King to look after. So this was the position. Now that went this like that only. The records of right was not corrected. Now in 2022, there was a correction of records of right by the state government. They said that we will correct it. The legal heirs of the landlord, their name has to be struck off. Because there was some report which was, they sought for some report, interim report by circle of a deputy commissioner sought for, and they found that this is a Khotole. And Khotro is known as Pirala Khotro. So they said that 2022 order has been issued by the state government saying that your name will be struck off. The legal heirs, their name was there in the records of right, it will be struck off. And henceforth it will be taken as a Khotro land. And these are under the one particular statute which is known as Assam State Religious. The name to some? Then I am told it. Assam State Religious Charitable Institution. So they on the basis of that, my lord, under section 15, the government said that it will be taken over. Now, this is known as Assam State Acquisition of Land Belonging to Religious or Charitable Institution of Public Nature Act 1959. And they invoke section 50. So now this is where now one of the legal heirs of the landlord, they approached this honorable court by filing a writ petition. 3003 of 2024, I think. They filed a writ petition for this honorable, challenging that order where they want to remove his name. Then they filed a writ petition. Government has also, we were not made a party in that case. We were not aware of it. And judgment went against them. So the order of 2022 that was not interfered with. So the records of right will go to Pirala Hotra. So one of the legal aids being agreed by the order of the learned single judge, they went before division bench. Division bench admitted that matter and this matter is pending now. This is one. Number two, in 2023, there was a public notice issued by the state government in pursuance to a judgment that has been passed by this Honorable Court, 3003 of where the landlord legal aids, and on the basis of a judgment that has been passed by the Assam Board of Revenue in 2005, where the entire land was declared as a Pirala Hotra. And they said, you are royalties maybe, but you are all illegal occupier. So you have to vacate that premises in 2023. I'm not putting exact 2023. This is a public notice. When we received the public notice, this was put to challenge before this Honorable Court by way of the present writ petition. This is a writ petition 5946 of 2023. We have put to challenge. And there was an interim order that was passed by the court. Our whole case, in very short, we said the right is, we have some type of right. Our right is accrued from a particular statute. Earlier it was 1935. We have given the chain in what manner, predecessor, how we entered into the shoes. Then we are protected under 1971 Act. This is what we projected before the court, and there was an order of a status quo order was granted by this court. Now the government came up before the learned single judge in this case, files an affidavit before the court. And they stated that no, there is already the matter has been decided by a learned single judge in 3003 of 2023 when all the legal heirs has approached this Honorable Court. That has been decided, which went against them. So they said what type of right? Original landlord goes, it declares as a Khotra land. Learned single upheld that order of 2000.
Board of Revenue.
Yes, and what 2000, that was not put to challenge. They came up with an affidavit. Then, my lord, then we are stuck. We said that yes, it's right. We were not aware of it. Then immediately we file a leave to appeal before the division. And we said that we were not made a party, we were not heard. Anyhow, we are agreed by that particular judgment. Because we ultimately the end result will be out. Now, leave to appeal was granted, the appeal was admitted, and that matter is also pending before the learned division bench. So this is a situation. Now, in this case, we also mentioned before at one point of time that this matter should also go before the division bench. We prayed before the learned single judge said that no, that has to be prayed before division bench. We went before division bench and we said that this is the position of the case. Now, the learned division bench at one point of time, they called it, this particular case, and it tagged with those particular appeals. In this manner, the matter was there for sufficient number of months, I think 4 months, 5 months. Then the state government said that it should be detached. It should be detached, this matter, it should be heard by a single bench. Accordingly, it has been detached and it has now before the learned.
Is it conducive to hear it?
No, that's the
in
point.
such
Why?
Position.
No, I said, my lord, that's the point where I started the case. It said, I find myself, if your lordship, there are some urgency of the learned. Let me put in this way because there is a status quo order. There may be urgency of the state government. But my personal, if your lordship seeks my personal, what is, I think that the matter should be heard by a division bench. This matter, because ultimately, let us say the division bench rejects or the appeals are dismissed, automatically this will also go. That's my understanding, man. So
Yes, my understanding is also same subject to. correct.
because now, your lordship, there are two ways. Either your lordship has to hear it and concur with the judgment of the learned single judge. Say that no, I agree with that. Or hear it, then this way, that way. Then no, I disagree. For a moment, I disagree that no. Then it will have a place before larger bench. So this best is, my lord, I don't know, my lord. The best would have been that it should, the division bench should hear this matter. Because it is, because
Why you
no,
have,
no, one thing, my lord, I just forgot one particular aspect of the matter to tell before this court. Now I remember. The Assam Board of Revenue, the order that judgment has been passed. We during the pendency of this case, we also challenged it. Assam Board of Revenue. 2005, we came very late in 2025. We thought that this has become a stumbling block for us. Because all that time when we go before any bench, the court will say that you did not challenge. That has come to 101 has been declared, you are there. So we challenged it. Ultimately, it has been dismissed. Against that, we preferred an appeal. Now appeal is pending before the. So now pending for division.
so 3 appeals.
3 appeals are pending for division. Now, my lord, the division bench, let us say it goes against us. No, these will upheld those order that has been by the state government. So ultimate end result is 0 in this case, my lord. Ultimate. Now, if your lordship hears this and suppose says that no, these are, I will concur with the same view that has been expressed by learned single judge. So again, end of the day, it has to go again before the division bench. This order has to be put to challenge. So my particular is that
So same parcel of land is in
101 same
involved. They
Yes,
are in
101.
all the 3 appeals.
Yes, 3 appeals, 101. And there is some urgency of the state government because there is a status quo order which has been passed by this. But let me put in this way. So there is some urgency, but all these matters are pending for division bench. And there is no stay order which has been operating in division. They only admitted because otherwise, my lord, the legal heirs of the landlord, one of the landlord, he is not in possession anyhow. They were not in possession.
Has he appeared?
Who, man?
Landlord?
Yes, one of the legal landlord that was put to challenge. He appeared and they filed an appeal again before division bench against that order of the learned single judge.
So basically in connection with the parcel of land, same parcel of land, there are 3 read appeals.
Yes. Because we also, when the Board of Revenue passed the order in 2005, so there was some finding of the learned single judge. I think your lordship will not go into that aspect.
So after leave to appeal
Is granted.
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 So you
Appeal,
appeal is
yes,
there.
appeal also admitted. Appeal admitted, and there also we sought some time to bring on record. But ultimately, we found that the trees of my legal predecessor were not is being connected properly. That whether we are riotees. So here also, my lord, we took a leave, and that was allowed. An additional affidavit is there before this court.
Yes,
These
Mr.
are all
Bhatt,
few things which has to argue before this court. Whether, my lord, a broader view, which I think because section 15, now the section 15 proviso says that suppose it is acquired by them as a religious institution. In 1959, there is a schedule. Schedule has been mentioned, which are the properties which have been taken, acquired by the state government. So there are schedules. So now our case was that it brings a Brahmotter property, Nisvikaras. It's a Nisvikaras land. So Brahmotter property, it was there to even look after. Now Devotter property, Devotter Dharmotter property. There are 3 criteria under Nisvikaras. So one of the argument is that if you are acquiring, you acquire by virtue of the order in 2022, 1959 Act. Now, whether section 3 was complied while acquiring it, because if directly under section 15, so then what they are saying that if you are acquired under section 15, you don't have any right as a riotees, because 15 provisos says that only protection can be given to same religion, not to any other religion. It is only in connection with the same religion proviso of section 15. So we are Muslims. So those are khotra, so you cannot get a protection. And this is in 2022, my lord. 2022, where they have acquired and they have invoked section 15. And by virtue of a report furnished by the state government somewhere in 2019, interim report.
Yes, what made you detach this petition from the?
If I may put it, my lord, I will take 1 minute, my. Sir, in a sense, my lord, this writ petition deserves to be dismissed at that threshold. Why I am making that submission? There is a parcel of land measuring 100 and odd acre. That land was recorded in the record of rights in the Jamabandi in the name of 4 persons with the title Goswami. They are the Pattadars. Way back in the year 2005, a proceeding was laid before the Assam Board of Revenue, where Assam Board of Revenue came to a categorical finding that this parcel of land belongs to a Satra. It could not have been mutated in the name of any other persons. So therefore, the land has to be restored and the records needs to be corrected. That was done. It was a declaration. It was a declaration by the Assam Board of Revenue, which is the appellate forum, my lord, in the realm of revenue jurisprudence, on the basis of materials available on record. From 2005, my lord, by a flux of time, nobody has challenged it and did nothing. In the year 2022, the government took an initiative that since this parcel of land was at way back in the year 2005 declared to be Satra land by the Assam Board of Revenue, so therefore the records are required to be corrected. And as a consequence, as a natural corollary of correction of records in the Jamabandi, the natural corollary will be eviction of all the unauthorized occupants over that parcel of land. Now, that was done. When the records were sought to be corrected, then one of those Pattadars with the title Goswami, Hiranya Goswami, he filed a writ petition before this honorable court. This honorable court, on the basis of materials on record, pleadings were exchanged. It was very, my lord, highly contested. At the end of the day, the writ petition was dismissed on the count that way back in the year 2005, it was already declared as a Satra land. And that decision of the Assam Board of Revenue has attained finality. That is the crux. Since that has attained finality, so nothing survives in the writ petition. That has to be, my lord, modified. Unless and until, my lord, that order stands, my lord, nothing can be done. It is a case of correction of records. And Assam Board of Revenue, while, my lord, disposing that matter, while coming to the finding in the year 2005, my lord, made several observations on the basis of, my lord, the history of that particular land, how it came to be Satra land, how it could not have been, my lord, mutated in names of individual Pattadars. All these things are there. Nonetheless, my lord, that writ petition filed by Hiranya Goswami was dismissed. Against that, my lord, the writ petitioner has preferred an appeal before the Honorable Division Bench, which is still pending, and no, my lord, interim protection in the nature of a stay order has been granted there. Now, in the interim period, my lord, when the records were sought to be corrected and there was no embargo from any judicial forum, including this honorable court, the authorities corrected the records. Authorities corrected the records and the names of the original Pattadars were struck out. They were struck off and the name of Pirola Khatra came to be incorporated in the record of right. Now, in the legal jurisprudence, my lord, when the entries in the records of right are presumed to be correct, unless and until the contrary is proved. That being the fact situation, as a fallout of correction of records in the year 2023, these eviction notices were issued. And these are the persons, Hasmat Khan, the writ petitioner number 1 hearing, and all other writ petitioners. They say that they are in occupation of those plot of land and they claim their rights not as absolute rights but as derivative rights on the strength that their forefathers were inducted as riots over those fertile portion of land, and those Goswami brothers were the original landlords. Now, under that circumstances, these notices were issued. So, since these notices were issued, and this honorable court in the earlier writ petition has already came to a finding that yes, that partial parcel of land belongs to Pirola Khotro. So therefore, they choose to file appeal before the Honorable Division Bench seeking a leave. That writ appeal was filed, leave was granted, and then that writ appeal is pending. Now, thereafter, challenging this eviction exercise, this writ petition came to be filed. And when this writ petition came to be filed, they got an interim protection, and it is continuing till date. In the meantime, that order passed by the Assam Board of Revenue was sought to be challenged. And some of the writ petitioners, they filed review applications under Regulation 151 before the Assam Board of Revenue. Or because that is the genesis. Unless and until the genesis is not, my lord, modified or rectified, one cannot have a derivative right. The genesis is well declared, it is evident on the face of the record. They filed review applications before the Assam Board of Revenue. Dismissed. Against that dismissal, they filed another writ petition before this honorable. Dismissed. Against that, my lord, a writ appeal is pending. So 3 writ appeals are pending. Now I am putting a question to myself. Unless and until the genesis till date has not been disturbed, it still holds water. It has attained finality.
No, right. Had those writ appeals been not pending, situation would have been clear.
Yes, yes,
In law, nothing is settled.
yes.
What was done can be undone.
Maybe. Absolutely, absolutely.
So everything can be undone.
Yes. Everything can be undone.
And sometimes the apex court says, or otherwise everybody know, a stay order by a higher forum is operating, non proceed.
Yes,
And sometimes they say, when we are in staging of the matter, how dare you? Both
yes,
lines are, they come with scathing attack. That we are in staging of the matter. I have
yes,
seen
yes,
recently.
Yes, yes, absolutely.
Why you High Court dealing with the same matter? There are every day
Everything goes.
the state will be having full power authority over this plot of land or sotro.
And till date.
Or the
it is
sotro.
sustaining. Yes,
Sotro.
yes,
And this automatically will become infructuous.
infructuous. Yes.
Yes, they are having some protection. That protection will last.
Yes, my lord, why I am apprehensive? Why I am apprehensive? Why I have made that submission? Because of the simple fact, my lord, that.
What is the order by which it is detached? Any region has been assigned?
My lord, yes,
Be-
at one point of time.
Let us
this-
have that,
yes,
the clear
this-
word.
This writ petition was tagged along with the writ appeals.
Ah.
Honorable Division Bench says that it is an independent cause of action, not connected to those writ appeals.
Let us have that
Yes.
order.
The court didn't say independent, court said let it be detached and it goes to the learned single judge.
It was in the mind of the court.
Yes.
No, mine is
Okay.
different.
No, my lord, what was.
What is there in the order?
I just tell your lordship, with that, I have a contempt application before the division bench. Then one of the party went to Supreme Court, only notice was issued. Court said, sorry, we are not taking up the matter because the notice has been issued. Till the notice, the matter is not been decided, will be kept in evidence, signed and. So, my lord, there was no way out. It is, I just prayed.
When these writ appeals are expected to be listed?
It was to list any moment of time, my lord. Why it is?
Last, my lord, those were listed, my lord, a month ago, prior to, my lord, almost 1.5 months or 2
Yes.
months. Yes.
What
And
is-
they are also, my lord, we have filed, because in the leave to appeal, that is an independent appeal, my lord, we have filed our detailed affidavit here, like the one we have filed here.
Granted.
Now, my lord, under that circumstances, in my respectful submission, if lordship may be pleased to dispose of this writ petition, because they have a right. Why I am making that submission? At the end of the day, it will turn again back to that square one position that 2005 order still sustains. 2005 order still sustains till today. without any judicial interference.
No, that is why there are many issues will crop up, which will be dealt by the division bench.
Therefore, if
Right,
today, if-
right to, eviction notice, their right to notice, but in the judgment, whether that will operate,
in the division
in
bench,
the
our
Board of Revenue judgment, whether that will operate.
absolutely, before the
Uh,
division bench,
When
arguments will
against
be
a one
dynamic.
party or not.
Absolutely,
All these,
Yes,
if the
yes,
division bench answers it,
yes.
dismisses it without answering even.
Because arguments
Goes.
will be dynamic from both the sides.
Yes.
They will harp on so many issues.
So from that perspective, it is.
No, yeah,
board is
again,
facing
once
dilemma.
again, my lord, why I'm
And
making that?
not only
if
one.
today- My lord, if today lordship again, my lord, passes an order for tagging this matter. it
No,
will-
no, I cannot.
No.
It
Yes.
is downward mobility, not
Downward
upward
mobility.
mobility.
Therefore,
So,
lordship may-
it's a difficulty.
We can
No,
just.
therefore, lordship may be
subject to-
pleased to
Yes,
dispose of this.
No, what I'm saying, my lord, it can be mentioned, my learned friend can mention it before the division bench. To list this matter, division bench, my learned friend. In the meantime, say, let this matter be adjourned till 2 weeks. And in the meantime, my learned friend can mention this matter. The matter
Those
can be
matter-
taken
if
up.
Those retails are dismissed, they are appeal. And landlord or landowner's appeal is dismissed. End of the matter.
My lord,
Because we cannot make a mention to that effect, because if we make a mention before the honorable division bench, because before the division bench, they are not in interim, they are not protected in the interim. So question will be put to us, why are you in a hurry? When we make a submission before the honorable division bench to the effect that kindly, my lords, that one writ petition is pending, how far that submission will be entertainable, my lord? Because we had made.
If I is filed, that will be attorneyable.
No, my
My
lord,
lord, what
at
we'll-
one point.
what
in
we'll
time,
do
we
it,
had made
If my learned
submissions.
friend is finding it difficult, I'm saying we'll mention it for division bench. We'll tell the division bench. We'll say, but the truth will say that this is what, there is some problem because we mentioned division bench, but as all these matters are pending, my lord will give a date so that matter can be taken up. We will mention. My learned friend is finding difficulty, we'll mention it, my lord. I'm saying we'll mention it, my lord.
Pertaining to what, a parcel of land, which is division bench is saying of the matter in 3 appeals.
Yes.
No, that is true, but
This-
here, my
this
lord,
is pro-
here,
this
no,
is the
but
issue.
here, if.
Therefore, I say 2 lines of observations. Right.
If lordship, if.
One
lordship-
is clear.
Yes,
One is clear so far as when interim order is operating. And the other line, sometimes they say, okay, we are not passing any interim order, what is the bar?
Yes.
And there is another line. Look, we are in staging of the matter. Why you are poking your nose?
therefore,
That is the difficulty.
lordship will kindly
But
appreciate.
deciding not,
No,
inviting unsolicited,
lordship
It
is
is-
correct. But so far as.
deciding is not the issue.
So far as this writ petition is concerned, this writ petition is concerned, on merit, they have nothing, they have no case.
No.
No, where is the prima facie case? The
Oh,
2005
Mr.
orders.
Orpuzar, you are not, I am saying deciding the petition is not the issue.
Well,
When you get it clarified, that independent of the pendency of the writ, it appeals,
Yes,
the single judge shall expeditiously dispose of the petition, then immediately next day I will hear it. You should have got the observation also while taking.
Yes. If lots, some, yes.
No, how can I? Oh, I will not give the direction to the division bench.
No.
It is-
I'm
you
not
make
even
that-
going for that direction. Well,
You
lordship,
say the single judge
They
is
are
having
using an interim
difficulty
protection and
in
we are in a
giving
situation.
consideration to the petition. If my lord can make an observation that in notwithstanding pendency of these 3 appeals, the single judge should proceed and dispose of the petition. You said, get an observation done.
That's an order, my lord, on merits. There is
Okay,
no-
let us-
There is an order on merits.
Let us have.
My lord. It was
I have
part of
just
affidavit.
gone through this.
If lordship may be these 2 periods, my lord, order dated 6/2/24. 60602/2024. ডিভিজন বেঞ্চ অৰ্ডাৰটো তাত কেনেকে কি দেখুৱাই
It's not recorded.
মই এফিডেভিটত আছে নেকি?
Inherent Land Council Board of Parties.
Lordship may be pleased to see this order, my lord. I have the order, my lord.
Okay.
Because this repetition was tagged at that point of time, yes. Having heard the learned counsel for the parties, we deem it appropriate to remand the matter to the learned single judge for consideration of the matter on its own merits. It is there, my lord.
Okay.
Lordship will kindly see.
We'll put it prominently
Prominent is better word.
on the
Yes.
first paragraph
My
itself.
lord, I ought to have pointed it out, my lord, at the first go.
Yes.
I'm sorry, my lord. I'm sorry.
Yes, we can start. On the first paragraph itself, we'll observe.
So many details, my lord, what I projected. Very honestly, so many details were not projected.
We'll not record that.
Yes.
All these repeals. Since on its own merits, we are unburdened by those.
Absolutely. So Lordship can hear. Lordship can hear.
Agreed?
My lord, I just.
On its own merits.
On its own merits.
So we are oblivious of
Yes.
all these three. repeals.
Absolutely. As if those.
And the
repeals
first
are not in
paragraph itself.
existence. Yes.
On its own merits.
Yes. Meaning thereby as if those readabilities are not in existence.
Yes. Shall we start today?
Well, let it be on again, one matter has been fixed, division bench. It be any date.
The next week,
Continue.
this is
Next
not
week.
there. First week of December. we
First week.
can have.
First
Let it
week of
be on-
December, my lord, on a hearing day, with,
On a hearing day.
I can only pray, my lord, if this is to be taken as the first item on that day.
No, we don't normally
I
ask
can only
that
pray.
order. I'll not break that convention, at least for my court. We don't upgrade matters. Whatever comes,
Otherwise, if Lordship makes an observation that we may be permitted to make a mention for upgradation on the next statement, only to that extent.
we'll remember the 2nd or 4th of December. The second of December.
Second of December will be. Tuesday. 2nd of December, Tuesday, my lord, yes, yes, my lord. 2nd of December. Only one observation, my lord, that we will be having the liberty to make a mention for upgradation. my lord.
No, you make mention, we will not observe that. Which we are not following at any time earlier. We'll say, what is that order? You said 6 to?
6/2/2024, my lord.
Okay,
Yes, Lordship can have
Mr.
it.
Didas, Learner Senior Counsel appearing for the petition, and Mr. R. Borpuzari, Learner Standing Counsel, Revenue Department, referring to the order dated 6/2/2025. 4. Passed in this repetition. Have submitted that the division bench has observed that this petition is to be given consideration on its own merits. Full stop. As sought for and agreed to by the learned counsel for the parties, lays the case on 2/12. Some
Interim order is continued.
Some synopsis.
দিবলে মনে হয়।
One page synopsis, because so many annexes may be
Yes,
Khotians.
yes, absolutely.
Say for 50 to
Absolutely,
120, it will be Khotians only.
We'll make a note
No, not.
Because
Interim
they are
order-
in the receiving end, they have annexed all documents that are available.
I have to
Definitely,
annex.
they will do that
Correct.
exercise.
My lord, interim order will come.
Interim order partially shall continue.
I'm deeply
Till
honest.
next effort.
We'll
And so-
we'll make a note of the matter, so it becomes easier for the court. With the list of dates and which page. I'll give a copy. Deeply.
Item number 6 for orders.
I'm so obliged.
What is the case about? Because service is not complete.
Your Lordship, regarding Najim Ahmed, in place of Najim Ahmed, some
Nazim Ahmed, what is Nazim Ahmed?
his
Take us
yes,
to that.
Chief Executive Officer, Your Lordship.
Which page?
This is in the cost title, Your Lordship.
Post title.
Yeah.
Post
Respondent, only respondent, Your Lordship. He is no longer in that post, Your Lordship.
Oh. Is no longer.
Yeah, Shah Nawaz,
I have to file.
Mr. S. Roman.
Double R.
Oh, double AR. Karim. Council Board of Petitioners and Ms. K. Fukan, Central Government Council. Are present, Ms. Fukan, near CGC, has submitted on instruction that the sole respondent namely Najim Ahmed is no longer holding the post of
Chief
Chief
Executive.
Executive Officer, Central Hajj Committee of India. Anyway, what his name is
Yes,
available
Shah Nawaz. Shah Nawaz.
so that he can implead. Right? We'll put it on a record. As and presently, comma, SHANAVAS, SHANAVAS, C full stop, is holding the office of Chief Executive Officer, Hajj Committee of India, Mumbai.
Your Lordship, one more matter is pending, similar matter, Your Lordship. Contempt.
Full stop. In view of such information, Mr. Karim, Learned Counsel for the Petitioners, has sought 2 weeks' time to file appropriate pleadings to implead the present incumbent holding the office of Chief Executive Officer, Hajj Committee of India, Mumbai.
Yes.
Full stop. You are otherwise requested counsel.
No, Your Lordship, already I have received the.
You file it?
Yeah.
List the case after 2 weeks.
Your Lordship, one more matter is pending, similar matter. Yes,
He is the counsel,
he is not the counsel.
and let it be like that.
Oh, yes.
Supplementary list, item number 19.
Huh? Oh. Oh. Mushan. Oh. Open get out time being to try. Nine, like matok. It doesn't put it.
19.
Nine.
Time being method, item 13.
Maybe they are trying to get instruction. After some time then, Mr. Talda is not there.
Answer was inside the court, your lordship. I'm informing, my.
Next to get it, 14 to get a coalition. And even.
Item number 14.
She is on late, Lordship. Court number 10, Lordship.
Okay.
For hearing, items 8 and 9.
Lordship, in this matter, Lance Senior Counsel BD Das appears, Lordship. He is always where he was supposed to appear today. But
My senior he'll be coming, Lordship, he's on the way, Lordship.
Why is the state? This is regarding that.
Must be there, your Lordship, because there is M. Bordoli.
At one point of time, I heard it. Who is the state council?
Yes.
Who appears for the state?
on the last occasion, Senior Counsel Mr. BJ Talukdar was appearing. And for revenue, Mr. A. Bhattacharya was there.
For revenue.
For revenue.
Yes, M. Bordoli was there, your Lordship.
At one point of time, I heard it. I asked for the relevant records.
Yes, Lordship.
Yes, Mr. Mehdi. There was an order by this court earlier. Relevant records produced earlier from the Office of the District Commission, Kamrup, obtained by Mr. Mehdi. Original records. Records are available, original.
Yes.
Okay.
Yes. My lord, a particular plot of land was given to the Assam petitioner, Assam Gandhi Smarak Nidhi, my lord. Now apparently, my lord, the land is being under encroachment of the other writ petitioner. Now lordship on an earlier occasion had the occasion of going through the matter. Lordship also wanted to know whether the process of this Rule 95A of the Assam Land and Revenue Regulation was followed regarding the reservation. So we have filed additional affidavit, my lord. Sorry, the Revenue Department has filed the affidavit where they have brought on record the proceedings under Rule 95A. Now, in the second writ petition which they have filed, I don't think, my lord, they have any locus to maintain the writ petition. And the Revenue Authority has filed affidavit where clearly they say that they are encroacher. Now, if your lordships would kindly come to the WPC number 463 of 15, the affidavit filed by the Circle Officer Guwahati, para Milord 9 at page 3. It was filed by one Damodar Bormon,
Para 9.
para 9, that as regards the statements made in para 12 of the writ petition, the opponent states that as per direction of the Deputy Commissioner White dated so and so, an eviction notice was issued by memo dated so and so to Gopinath Nagar Masjid Committee for eviction from government land covered by Dag number so and so, allotted to Assam Gandhi Smarak Nidhi of village Ulubari Moza in the district of Kam. Apparently,
Oh, I
second writ
remember.
petition, my lord, there is a stay.
Ah,
Now, this is the case.
ah. And I remember now. After
So lordships also wanted to know
after
whether
something.
there was some agreement in to.
Yes. What is your statement on it?
My lord, done away with, there's nothing.
No,
nothing.
done away it is different thing.
Ah.
Whether you executed or not executed.
There was, my lord. By the, now, my lord, the earlier office bearer, they have died also. Now, my lord, new office bearer have substituted themselves.
That is a different issue, but I asked the specific, I remember now, whether that was executed or not
It
executed.
was done. To be honest, it was done, but the was never, my lord, carried forward, and the earlier.
How, to what extent of the allotted land?
No, only, my lord, agreement was done, nothing was done.
Registered agreement?
They have,
It looks like registered.
yes. Mati diya. But then, my lord, the other writ petitioner, their, my lord, rank encroacher. Whether at their instance, my lord, any writ petition is maintainable.
Which affidavit you are seeing?
I was
Your
referring to
affidavit, any
affidavit.
affidavit to the affidavit in reply to their affidavit?
No, my lord.
This private respondents?
Right. Oh, yes, yes. In their case, it is there.
No, here also they have filed an affidavit, I think.
But in their writ petition, it is there, my lord.
No, here, 4 and 5.
Yes.
Any affidavit in reply?
They have annexed in their affidavit at page number 10, my lord.
Any reply to that?
5, 4, 5 reply कर रहे हैं.
I'm just sorry to intervene, my lord. 14/2/22, your lordship's order.
14 to
2/22. Government is to produce records as regard VGR land, my lord, when they have.
No, I have asked for the original. He is saying, Mr. Talbot says.
The state has filed an affidavit, page
They have
58 to
not said,
61.
This is your lordship's order, pursuant to that.
No, my
is
lord,
to produce record.
whether we get this
Sorry,
land
lord.
or not, that's a separate aspect. What is their locus, my lord, to intervene in this proceeding? Who are they? Their rank encroachers?
I'm just showing the court's order, my lord.
Who are they?
14?
14/2/22.
They have filed an affidavit, my lord. They have brought on record all the
It's
notices.
my duty to point out, my lord. The order passed on 14/2/22.
আমি এখনো এফিডেভিটৰ ৰিপ্লাই দিয়া নাই নেকি?
Okay.
বহুদিন হ'ল নহয়, পাহৰিয়ে গৈছিলো। এতিয়া তাতে যে গাঁঠি দিছিলে যে হেও
Whether it has been de-reserved.
Annex
My lord,
Four.
secretary, joint
Next.
secretary has filed an affidavit, my lord, where they have clearly stated that how it was de-reserved.
No, I need the records. Mr. Talda, you have the records? No, I asked for a specific. If now everything has come back to my memory, I asked entire reservation record. How it started.
That is what is important.
It looks like cart is before the horse.
No, my lord.
Maybe
They have put.
no, I need the records.
Oh, yes, lordship will have the look at the record.
I'll have to satisfy. It is a premium land otherwise.
Yes. No, it's a valuable land.
Valuable land. And what is the zonal value at that point of time?
4.5 lakhs. I think we paid, my lord. We paid 4,50,000.
Because in another case of similar nature, when
No, it was in 2008.
2008, I remember 2014, when zonal valuation was placed, Ulubari or that area, it was about more than 1 crore.
No,
Yes.
no.
There was
My lord, in Rupnagar area where I stay, there, my lord, I think about 2005-06, some lands were given on premium, our adjacent lands. I think it was for, initially it was 2.25, but subsequently it was reduced to 60,000. Initially it was 2.25. Subsequently it was reduced.
Okay.
It was increased subsequently, my lord. I don't think around that point of crore, it was never.
Because 2014, one chart I remember, it was placed. The amounts are quite
I think, my lord,
quite high.
even 2000.
You were there or what?
GS Road, it was zonal value was not 1 crore.
Huh?
I'm sure. Even
No,
in
no.
2008, even GS Road. it was
Maybe,
not 1 crore.
but 2014 I am saying. When zonal valuation was there, it was in crores. Bigha. And what is the land policy at what price it is to be?
I think we paid 4,50,000.
And what is the land policy?
Land cost
Land policy.
policy
Huh.
presently.
No,
At that point of time.
1989.
89 policy was holding the field.
1989 policy.
Yes.
No, 1989 land.
এই আমাৰ গ্ৰীণ কিতাপখনত
সেউজীয়াখন থাকিব পাৰে।
গ্ৰীণ কিতাপখনত থাকে
89 খন।
আছে
What is the land value you have paid?
4,50,000.
At what rate?
Page number 24. 1 second.
Annexure 6, 4,50,000.
Annexure 6.
Page 24.
24.
Deposited 4,50,000.
Land value 3 lakh. So it was 12 lakh or 15 lakh per.
No, for 1 bigha we paid 4,50,000.
No. There will be reduction in premium.
Kindly come to page 26.
Come to page 23. The land value is fixed at 3 lakh only per katha. So 1 bigha is 15 lakh. 5 katha is equal to 5 lakh is equal to.
Oh yes, it was 15 lakhs.
Per
katha 3 lakh.
Per katha 3 lakh. So at what rate you have been giving?
On 3 lakhs.
How much?
3 lakhs per katha.
How much you have deposited?
We have deposited 4.5.
How much area?
1 bigha.
1 bigha.
Yes.
Any discount?
No. Possibly this was a token payment, Miller.
No. With token payment, you cannot be settled.
No, Miller, we were.
There can be advance, yes.
Could be advance.
But what is the total amount?
Yes. Total amount will be 15 lakhs because it is 1 bigha.
Yes. What is the,
Only out of that 1 bigha, part of them are occupied by them. That's why possession could not be given to us.
position is one,
Miller,
title is
it's
one.
not a case of settlement, it was a case of allotment. Once we pay the full amount and all, then only Miller, this patta will be issued in our name.
The position of the land may be handed over to the authority concerned and the land records may be corrected and patta issued after realization of the premium in full. What is the amount you have deposited?
No, I'm sorry, Millard. Please come to page 23.
Huh.
We are given a Millard discount. Kindly come to the, with reference to the letter on the subject cited above. I am directed to say that Governor of Assam is pleased to recommend for de-reservation of VGR land measuring 1 bigha covered by Doug number so-and-so village Ulubari and then settle the said land with Gandhi Smarak Nidhi for an establishment of Gandhi Sangrahalaya only subject to payment of 30% of the value of the premium as premium.
What is the premium policy?
State will
State. What is the premium amount?
Premium play, I don't know, the government will be.
Mr. Talukdar, you have to answer 30%. Yes, we are looking at it without, with a dispassionate thing.
No, Lord, I have appeared in this case at least 30-40 times. Rossi will take a call, Mr. That's my
I am
argument.
taking a call,
Yes.
but I need the records and the policy.
That is what is important.
Let them produce the record.
Records de-reservation proceeding and plus market value plus what is the policy about premium?
On the date of allotment.
What is the premium amount? Because you are giving it at 30%.
Yes.
And it is located in Ulubari.
It's not exactly Ulubari, Milord. It
No,
is
Ulubari,
towards that.
Ulubari,
Milord, I think
Ulubari, Sohar Ulubari.
Milord, Sohar Ulubari, it is, I think, near that Guru Nanak school. Near Guru Nanak school.
Premium. Reservation proceeding is there, records. From the very beginning.
The 95.
Not from the proposal. I remember. Government directed. Let us see. Government directed.
Has to initiate it from the deputy commission.
Yes, direction. Nothing against anybody.
Yeah, no.
Let me have the. Oh, I thought that it was disposed of. Where is the government letter? You show. It is top to bottom. How far you have sought for possession with eviction?
No, Milord.
As a-
Initially, the government was not aware of the fact that the part of the land is being encroached by the other petition.
No, this is for my assistance from a senior counsel.
Yes.
You have sought for eviction and clearance of the settled land.
Yes.
Yes, you have deposited the premium. Money as 1 bigha has been settled with you.
Allotted.
You allotted. Not allotted, settled.
I think all is allotted, no? So settled.
Settled, not allotted. Settled. And you deposited premium, but you could not take possession.
Partly.
So, but suppose court notices illegality. To what extent a writ court can go, apart from the facts of the case?
Lordship will refuse relief. If I cannot satisfy your lordships that something is wrong in the settlement or allotment process, lordship will refuse the relief.
Now, to what extent we can go?
So lordship will dismiss my writ petition, that's all. Because in that case, I will be not in a position to establish my right.
So-
Or even if there is a right, the right is tainted.
And if some perceived illegality in the process,
Yes.
in that case,
Lordship can refuse the relief.
yes, Mr. Das.
That is the law, my lord. Your lordship will kindly see whether 95A has been followed. That is very important.
95A, yes, right.
Three judgments are there. And also premium, the government will stay.
Premium amount you have to say.
And in the other case, my lord, the government has issued a notice saying as per the High Court order, you are to vacate.
No, because why I am saying, suppose you are refused relief, suppose. Some perceived illegality in the process. But there are also,
No, my lord, their notice will survive. They will have to satisfy independently of my standing. Whether they have a case to occupy government land, whether they can set up a masjid in a grazing reserve. That is the point.
and if the VGR land is de-reserved,
Ah.
without following due procedure,
Then also it is not correct.
it may not be correct.
Yes.
Then you go, he go.
He also goes, yes.
He will go.
Ah.
Then
Mine is, my lord.
suppose,
No, yes,
suppose situation what I am saying,
Correct, correct.
if the entire process is wrong, then you go, that is why I asked,
Everybody goes.
everybody goes, VGR will,
Remain as VGR.
it will be restored as VGR,
Yes,
then everybody will be cleared,
yes.
then thereafter, new process, new thing, whatever,
Up to the government.
up to the government. Because now Jagpal will come in,
Yes.
right? Thereafter,
For the government to take a call.
okay. Yes, Mr. Das.
And in regard to the petition filed by the present respondents in the other case,
Yes.
1236, 2017.
You have been served notice or what?
Yes, we have been served notice for eviction that we are in possession of there is a masjid and a mandir for last 20 years. There is no mandir, my lord. Well, let me submit, my lord. These two committees are before this court. If he knows more than me, my lord, he should take my brief. My lord, your lordship will kindly see there is a notice.
Which page?
Notice, page 40, my lord. 40. On the page, yes, government can take action against me. I'm not saying that they cannot take. They, for kind of, as per High Court order. There is no High Court
40.
order. my lord. Yes,
In your petition,
yes.
1236,
41.
page 40 notice, yes.
This is for information that as per order passed by the Honorable Guwahati High Court. Where is the order passed by the Honorable Guwahati? This is-
463.
Yes, the other case. I'm not saying because this is a VGR land, my lord, they can be evicted. It is left to the government because if it falls within the public premises, my lord, government may, there is a provision for settlement also. But government can take action. I'm not denying that.
And who is this Sudeep Soikia? You represent him also.
Sunit Sekhe?
Another encroacher. He is a party.
No, I'm not part.
Whatever.
So this is as your lordship knows, my lord, this is a VGR land. I am there for last 20 years. They are trying, there is an effort to settle them. There is a provision for evicting me. I'm not saying that I cannot be evicting me. And this petitioner will have an opportunity to file representation. Say, and the government is in a position to decide the matter. Because the court's orders are there, it says, my lord, in public, in view of the public, my lord, if they are involved in public action, my lord, so therefore government may consider, may not consider. But Jagpal says that only. My lord. But this is on the basis of the court's order So this is how I am linked, my lord. Who is interested so much, my lord? So a circle officer has issued this notice on the basis of the High Court order. I don't find any High Court order, my lord. All pages are there at page 38, 39. This is the High Court's order I find.
Because circle officers, ADCs, DCs are writing, mister.
They can
Taluja,
evict me, my lord.
where is that letter? That government letter that you showed me that letter. It had a reference of a government letter. Oh. No. প্ৰসংগত উল্লেখিত চৰকাৰৰ চিঠি আৰু বিষয় সন্দৰ্ভত সন্মান সহকাৰে চৰকাৰে বিচৰা মতে গান্ধী স্মাৰক নিধিৰ নামত সংশোধনী প্ৰস্তাৱ দাখিল কৰা as far back as 2002-3.
More than 20 years. 23 years.
Reservation process is in 2005.
My lord, I'll give
The
just
What?
order says after the result.
after the
Page
result.
23 order says after the result.
No, I saw start
Initial proposal.
initial proposal. It flows from top.
It has to go from below, my lord.
No,
Because the application was always be made before the government. We approach the
no,
government.
you clear a lot. Let's have it. Can you go through it? We'll see. Otherwise, I think your submission is complete.
My
If it-
case is very simple, my lord.
Uh-huh.
When we file this petition, then the district administration could notice that the land is under enforcement. Since proceeding was there before the High Court, therefore they were issued
At 2
notice.
o'clock, we'll look into the record. If any clarification is required, only from the government, it will be required.
Yes, yes.
Sir, I'll just place the Jogbal case once.
Okay, sure.
I'll comment.
Then we'll close it
Yes,
unless some information from the government,
yes.
no submission from the parties. Go through it.
From my side also, I concluded only the Jogbal one sentence I will show. They can evict me. I'm not saying they can evict me. But they will have to issue.
In the second case, what is your case? Otherwise, what you are challenging?
No, I'm challenging that a notice has been issued in the name of. Of what?
Well, supplementary yesterday's list 19 and 20.
Yes.
Lordship, I may be permitted to withdraw this case. No. No, Lordship, it's partly for other case. On instruction.
Hartsi Borua, Mr. Alliance Standing Council, NHA, for the applicant, and Mr. A. Das Gupta, Alliance Senior Counsel, assisted by Ms. B. Das, Alliance Counsel for the opposite party, post of Mr. C. Borua. Mr. Borua has submitted on instruction that has submitted that he has instruction to withdraw the instant application. Post of in view of such submission of Mr. Borua, the instant interlocutory application stands dismissed on withdrawal. Same 20.
Next,
Item 19 and 20.
my lord. Obliged.
I'll just, our case is in the next file. That page 40, impugned eviction notice in the name of the High Court order. 40, 41, 40 was in his assumptions.
Here you have come with what prayer?
That for setting aside that eviction, that notice,
Impugn eviction notice.
which has been issued. Admittedly, there is no High Court order, but it has been issued in the name of the High Court.
Okay. Otherwise, what is your
My.
right to possess?
No, I don't, they can, well, not visual land. I'm there since as on 2017, 20 years. As on now, well, it is about 28 years. So if the government wants to clear the visual land, they can clear. There is a process. I can give application for consideration that in terms of that paragraph 23 of the Jogpal case.
Jogpal.
Jogpal says, well, public utility, you can. If they give notice, I'll say that this. Here.
Jogpal. Maybe they are here. Okay, Jogpal. Paragraph.
23, my lord. Paragraph 23, ma'am, the last line, my lord. Regularization should only be permitted in exceptional cases. Example, where lease has been granted under some government notification to landless laborers or members of scheduled caste, scheduled tribes, or where there is already a school, dispensary or other public utility on the land. So this being a masjid, my lord, if they give me a notice, then I'll have to say that it is a public utility land. Government may consider, may not consider, but they'll have to give me notice, but not a notice in the name of High Court's my lord order, which is not in existence.
Jasmine একেলগে। Yes, let me have a look at the records.
Yes. Ma'am. Everything is this one. So if your lordship finds that 95A has not been followed, the whole process goes. And to me, my lord, they can issue notice if they wish as per law. I will have a right to represent. That is the crux of the matter. There is another order in regard to this, but. Yeah.
That government letter is available. When this was formed, your body established
Registration. I think.
what Gandhian principle you are disseminating?
So my lord, these are probably.
What
some
kind
any-
of work you are doing?
Nothing as a date.
Nothing.
Nothing, because the land is, I have some photographs, land is land is not occupied by us. because they could not give us the.
So as a Gandhi Smarak Nidhi, what kind of Gandhian principles you are disseminating? Anything?
As of date, and nothing.
Settlement official. Everybody is referring to 2204/2023 letter. Huh.
In fact, the.
I'm at 2008. Premium. What is the rate of premium?
3
Huh?
3 lakh per kotha, but at the rate of 30%, they were
Huh.
asked to deposit.
On what
That
basis?
later, Lordship will find that note.
And I have seen note sheet.
Yes, madam. Page 10 or 11.
Ah, 30%.
30%.
On what basis?
Basis is not known. on
So
this.
20-25 हुआ whole. So 20-25
So
हुआ
market
whole.
value is 3 lakh. So it comes to 15 lakhs and 30% of 15 lakh.
So 20-25.
So this process, I don't find that late.
Hmm?
At page 24, 25, I don't find it. Maybe somewhere else.
No, so 20-25.
There is a page 24 is there, but
Ah,
this is something.
total 30%.
It would be-
Where you get the premium? Your premium is also policy.
Premium normally my lord market value calculated for the last 3 years.
No, no, this reduction, discount.
That of course I do not have any. How it came to, how it was fixed at 30% of the market value.
Because it is normally 100% for townland.
Yes. In some letters, I found that it was until the full payment is made.
That is a different issue, but you have fixed 3 lakh and you decided to
Then-
settle the land 30%. Normally
What
it
is the
is,
basis?
normally it is allotment normally.
The full
After allotment, within 3 years, if it is used for the purpose for which it is allotted, then it is settled.
Otherwise it
But
is not.
here, straightaway settlement. Then that too at 30% premium.
Basis I don't find. Here.
Where is the, how do you fix the premium? I have seen some notification that this premium has to be at least at the government value and townland. That too in a metro or city. This doling out premium land at 30%. And here it is first allotment, settlement, decision to settle. Then you do the reservation, de-reservation. 95 says, no, 95. First volume.
90-50. First.
Yes, Mr. Dhor, anything?
My lord,
Highlight on premium,
page,
because we find something.
page 11 may
really-
be the answer, my lord, of the records.
Huh?
Page 11 of the records may be the answer because it says the entire plot of land could not be handed over. As on 12/1/2010.
No. Initially, idea was conceived for 2 bighas.
Yes,
2 bighas,
then
then-
it came
Then
down to 1
it is
acre.
enclosed, so 1 bigha could be allotted.
Yes,
So decision been changed.
yes,
So 1 bigha means 5 kathas.
5 acre.
5 kathas means 15 lakhs. 15 lakhs means 15 lakhs. But how it came to 4.5
30%.
lakh? 1
That-
bigha land. Then it should have been tender. It would have
But-
fetched at least 1 crore.
But the process from the record, it says that the process was started since 2003. Page 6 of the records.
Decision to allot.
Yes. And to de-reserve the land.
But so it is basically Uttapur.
And the case was
He has
registered-
been given no option
no option.
but to the reserve. And who is the man? He is an Indian Administrative Service sitting in commission as commissioner, secretary, what? Chief secretary.
Chief Secretary.
Oh. Chief secretary wants 1 bigha land. This Borua? He was chief secretary.
No, I think,
I
I'm not aware of that.
No. It is said somewhere, IAS. It is there, sir. How can the deputy commissioner disobey a man who is IS, maybe chief secretary or
Top of the
secretary?
hierarchy in the town.
And what he had what he had done as per the registered instrument to his son-in-law.
That I am not aware of that.
No, mister, you don't aware. Somebody said, Mr. Kolita, where is Mr. Kolita? He is his son-in-law. The builder? Huh?
That time.
Somebody disclosed.
I'm not aware of that.
The development agreement.
That was not acted upon any point of time.
Acted upon is one thing. Execution is another thing.
Hello.
You could have acted upon only if you have been
Only
given
if
clear
if
position.
They could have taken the position.
And 95 says deputy commissioner is of the opinion. So opinion has been imposed.
It
It is
maybe
there.
from the-
Right from 2003.
Yes.
Allotted UD reserves. And what notice? Only in his office.
The process started from year 2000.
In his own letter. I'll not name, I think he expired. He wrote in his own signature, IAS, writing to the Deputy Commission. Please refer to government letter mentioned above, accepting your proposal to reserve 1 bigha land, Ullubari Vizier. He knows Vizier. With Assam Gandhi Smarak Nidhi. I would like to request you to pass necessary order de-reserving the land. He says, as an IAS, to the additional deputy commissioner, your letter. Chairman. Mister, I want to dig more into it. You get the premium. I am keeping it, the records. Premium,
How it was calculated.
how
It
it
was
is
reduced.
fixed at 30%. By letter dated 30th January 2008. And at that point of time, what is the zonal value
Prevailing market.
and what is the policy for fixation of premium for settlement of townland? These two aspects. Other things are getting clear, except that letter we could not find, where everybody mentions so that generally somebody writes the government as directed by the Honorable Minister. Like that, everybody is writing as directed by the government. All the circle officer, settlement officer, they are writing as directed by the government. File letter dated 22/02/2023. 2003.
Perhaps Lordship has got the letter dated 31/2008. That is at page 24.
Huh?
That is the order passed by the governor, perhaps. Not quite sure. That is
24.
page 24.
Huh? That is why I said.
Governor of Assam was placed to.
Governor of Assam. And governor's decision is taken by the secretary. Here it is under secretary.
Under secretary.
Secretary includes under secretary as per the rule of executive business. So this part, Only this, but other instructions are
I'll
okay.
take instruction of the fixation of the
Heard
premium and
Mr. K.
how.
Chaudhary, Senior Counsel, assisted by Mr. Edhor, Learned Counsel for the petitioners. Petitioner in 8. And Mr. B.D. Das, Learned Senior Counsel, assisted by Mr. K. Kolita, for the respondent number 4 and 5 in WBC 463/2015, and for the petitioners in WBC 1236/2007. Actually, Endor are likibo for the respondent number 6 in 463/2015. Was also heard Mr. B.J. Taluder, Senior Counsel assisted by Mr. P.K. Mehdi, a learned State Counsel or the state respondents. Full stop. Para. Mr. Taluda, learned Senior Counsel appearing for the state respondents, shall obtain instruction on 2 aspects. Firstly, what was the journal valuation for lands? Journal valuation fixed by the competent authority, stroke government, for lands during the period from 2003 to 2008. For village Ulubari Moja, semicolon, and secondly, comma, what is the policy of the government for fixation of premium for settlement of townlands measuring 1 biga at village Ulubari Moja during the said period. And thirdly, comma, is there any provision for fixation of premium at lower rate than the journal valuation? And look, thirdly, boli ki kolo? And if yes, comma, at what rate the premium is to be, at what lesser rate premium is to be fixed as against the land value. Okay. The records placed by Mr. Taluda is are kept with the case record. A copy of this order is to be furnished to Mr. Mehdi to take necessary steps from his end. Yes, Mr. Dhor, what is the judgments you are relying upon?
That my senior.
Jokpal.
That was referred by Mr. Senior Counsel, Mr. Das, probably, no?
Oh, these are not. Earlier, in the earlier round it was placed.
But the lordship has taken any date.
Oh, at least the case on what date we propose?
After, because probably the policy will be from the government, so we have to write to the government also. From Deputy Government.
2nd of December. No? 2nd of December. As part of it. 8 I will not be available.
Second, I have some difficulty, some other fixed cases are there. Any other date?
Only this instruction in writing.
I may not be there.
Maybe you will do. Only this instruction in writing. Nothing more. The policy is available, the policy. Because you fix rates from time to time. And discount also.
That to why 30%?
Hmm?
That to why 30%?
100 to why 30%. Doling out the premium land at 30%. Raises some, may not be correct. Requires some,
Some justification, some logic.
no justification. So if it is already laid down that 30%, then this should have been, there are much more, many organizations who are doing much better work. It could have been.
Obliged.
And Mr. Kolita has brought on record a registered development agreement.
That
That is quite abhorrent to the policy professed. How can you take a VGR land, thereafter execute a registered development agreement for multi-storied building, multi-storied residential building, 4.5 lakh, 1 bigger land, then you execute an agreement with builder, multi-storied building containing how many flats? And what are the furnishing? Marble and all this. 4.5 lakh. This is
I can understand, but
catches the eye. And you also tell me correctly, what is the relationship of this man court is digging deeper. I don't know what to what extent court can dig deeper. At least the information should be there. Where is Mr. Kolta agreement?
Affidavit filed by the respondent 4 and 5,
Ha,
page 10.
yes. This agreement is executed by the same IS,
Yes, Lordship. Page,
same IS officer.
as reference is page 24 of the requisition, Lordship.
24.
Page 24 of the requisition.
What does it say?
Deputy Commissioner has wrote to the Karunakanto Burua, IAS retired. Lordship. So he is the IAS officer.
No, he is signing as IS. In his communication to the circle officer and
And Deputy Commissioner. also
Deputy
wrote,
Commissioner,
Page 24 of the requisition, Lordship. WC 463 of 2020. This is Deputy Commissioner letter.
and Nidhi will get
Regarding the distribution of flat Lordship,
Ah.
fourth paragraph of page.
Fourth.
Second, internal page 2 Lordship of that agreement. And whereas both the party has mutually decided in between themselves and agreed the first party to take 4 independent flats measuring 12 square feet super build-up area is on the first floor to 4th floor and a single story 4 RCC building with foundation of 3 story as the consideration of in lieu of price of transfer of ownership as well as the handing over possession of the schedule A land to the second party builder.
second party builder. You have not controverted it.
But no, we have not filed any affidavit. But the paragraph second and third paragraph also speak something else. It's only 5 letters with regard to 5 letters. This is with
Out of that 1 bigha.
out of that 1 bigger, which was not under his position. And the consideration was for building for the purpose of Gandhi Sangralaya. That is also mentioned, paragraph 3.
Yes.
Hello. Obliged.
This Prashanta Barai find out.
I'll try to figure it.
One more. Yes, yes.
I have
Any-
received the report. One case was charge sheeted somehow.
What did you say, Mister, in your petition?
That police did not take any.
Where are the insurance funds, so?
Oh,
Written as on 8/4/2025.
that's good.
Sahida Bibi. Petition is Sahida Bibi?
Yes.
Huh?
Yes, madam.
Oh, Sahid.
Tahira Bibi. Tahira Bibi.
Yaqub Ali. Golokganj Police Station, case number 118/2024. Section 8 POXO. Searched on 31/10/2024. Second incident. Also registered 280/2025. 87/127 BNSS read with section 4 POXO. Investigation is ongoing. Third incident.
Third incident is not registered.
Third incident is not your case
Not-
also
not
in the
by-
petition.
Not by them, by some village defense part.
No, but,
So
it's case
nothing is
18
left.
I don't, case 18. FIR was lodged by the petitioner with the third incident.
Page?
Page 18 is the translated copy. Particular at 20, your lordship.
Let us read 18.
20.
18 of particular.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে নিম্নলিখিত আসামীজনে মোৰ নাবালিকা ছোৱালীক আৰ্যফা খাতুনক মিছা প্ৰেমত ফুচাই যোৱা